certificate for CPD, then again, you can pop me a message after the seminar and I can send you that over. And I think that's about everything. So without further ado, Sarah, I'll hand over to yourself.
Thanks very much. Hi, everyone. So we can just move the slide on, Jen, please. So today we are looking at the vexed question of compensation events under NEC. So we can just move the slide on one, please. And is this the most problematic area of NEC? That's a rhetorical question. So what are we going to be looking at? We've got a number of clauses, so they're all within the clause 6 section, so 60, 61, 2, 3, 4, 5, dealing with compensation events. So what we're looking at today, and really this is a little two-part series of seminars within our whole series this year. So today we're looking at compensation events in terms of the process. We're not going to be looking at individual compensation events. They're at clause 60. And then next week, we're looking at the related topic of schedule of cost components. So they're two quite tricky topics. So try and keep them fairly simple. So today, as I say, we're focusing on the CE process. So we're going to be looking at notifying a compensation event, why that's important, who needs to do it and when. So the time limits. We're looking at submitting the quote by contractor or a subcontractor in a subcontract. And please be aware, you know, if you are a subcontractor, when I'm talking about contractors, I'm talking about you as well. So also, if you're a contractor who's subcontracting, then you've got two hats on here really, because you're going to be applying for payment in your contract, but also you're going to be effectively the project manager role within your subcontracts. We're going to be looking at accepting quotes by the project manager and what happens when they're not accepted. We'll look at project manager assessing a compensation event quote, and finally incorporating changed prices and dates into the contract. So if we can have the next slide, please, Jan. Thanks. So that kind of ties quite nicely with the clause numbers. So as I said, clause 60 lists the compensation events. We're not looking at the list today. There are other compensation events as well in the X clauses. What I would say is when you start to think about notifying a compensation event, I think it's really good practice to always look at that list in clause at section 60 and also the X clauses, because sometimes you'll find that actually you might have thought it was the CE under one provision, but if you continue looking down the list, you might find other CEs that are relevant. That's all I'm going to say about clause 60. 61, notifying. So this very much follows our agenda, notifying a CE, who does it, time limits, etc. 62, submitting a quotation. 63, PM assessments generally. 64 PM making the assessment, project manager, and finally 65 implementing the CEs. Now, the guidance notes have various flowcharts in them, and this whole process consists of 20 pages of flowcharts. So I've tried to simplify that. The other thing I want to say on this slide is EWN, early warning notices. They're dealt with at clause 16.1. We're going to be touching upon them. But just bear in mind, they are required, but it's dealt with in a separate section of the contract to the compensation events, and it is separate, albeit related. So next slide, please, Jen. So I've done a little sort of flow chart on the kind of time limits and a summary, just because it's quite a convoluted process, and I think sometimes we can kind of get a bit tied up with it. Now, be careful, because some of these timescales are different in subcontracts, and also what you will find is that where there's a timescale for the contractor or subcontractor to do something under NEC, quite often in the Z clauses it gets amended by reducing it. So the first step when we think there's a compensation event, typically, not always, but typically, is the contractor's CE notification to the project manager. So basically the contractor notifies the compensation event to the project manager. Timescale for doing this, 8 weeks from the contractor becoming aware of it. Quite often that's reduced, as I've already said, in the Z clauses, so in the specific contracts. The most common, sometimes it's reduced to 6 weeks, but often to 4 weeks. I think that's very unfair to reduce it in that way, mainly because this clause 61.3 is a condition precedent. So what does that mean? Well, it means that if the contractor does not notify within that 8-week deadline, or 4 weeks if it's been amended, then contractor still has to do the work, but does not get paid for it as a compensation event and does not get any extension of time. So potentially would also have to pay liquidated or delay damages to the client stroke employer. So, you know, this is a really, really onerous clause for this reason. So that's the first thing to note. We will come back to that, because it's not every compensation event that has to be notified by the contractor, but hopefully you can see that with such onerous consequences, it's probably best to err on the side of caution and just notify. If in doubt, notify a CE. So let's assume contractor has notified the CE within 8 weeks of becoming aware of it. So that's good. First step, tick. So this is like a game of tennis. The ball is now in the court of the project manager representing the employer or the client under the contract. So what does the PM have to do? Well, the PM has to either agree or not that it's a CE, and if it does agree, it needs to instruct the contractor to prepare and issue a quotation. What's the timescale? Well, the project manager has 1 week from receipt of the contractor's CE notification to do that. So the project manager is doing 2 things there. Number one, do they agree it's a compensation event or not? And if they do agree it's a compensation event, they tell the contractor and instruct them to provide a quote. So there are effectively 2 instructions within that notice, and that's within a week, clause 61.4. So in our game of tennis, the ball's back in the contractor's quote. Well, what does the contractor have to do? Well, what it's been asked to do, submit a quote. It has 3 weeks to do that from the project manager's instruction, and that's clause 62.3. Contractor submits the quote, hopefully. Why wouldn't it? And then the project manager has 2 weeks from receipt to respond to the contractor's quotation. So what will the response be? Well, it might be, yes, I accept that in full. It's a lovely quote. I agree the figure. It might be, reject it. Please provide something different. Or it could be that the project manager says, I'm rejecting it and I am going to now proceed to make my own assessment. So I'm going to set out what I think the value of the CE is. And that's the next line in the slide, where the PM makes an assessment. So what is the timescale for that? Well, it's due within 3 weeks of the last deadline. So within the project manager's notification to the contractor that it is going to make its own assessment. And that's 1 week in a subcontract. So that very, very roughly is the process. It sort of makes sense if you think, you know, it's pretty logical. But what the contract doesn't say is things like, you know, what happens at the start of the project if contractor notifies a CE and the project manager says, I don't agree that that's a CE. What happens then? So we're going to kind of look at those types of scenarios. Before we move on to the next slide, though, just the final bullet point, the note that what I call the default provisions, really useful if you're a contractor in a contract or a subcontractor in a subcontract. And they give you some power in the event that the project manager doesn't comply with any of its deadlines in this slide. What it does is that if the project manager doesn't respond within the deadline, the contractor or the subcontractor in a subcontract can issue a notice to the PM to tell them they haven't responded within the deadline, so they're effectively in breach of contract. You've got to give them another 2 weeks in the notice, and if within 2 weeks from that further notice the PM still does not respond, then the PM is deemed to have accepted whatever notice the contractor has issued. So if, for example, third line down, contractor submits a quote within 3 weeks from the project manager's instruction, contractor submits it, and then we can see the next line down, PM has 2 weeks to respond. So in our example, PM forgets to respond in those 2 weeks. What does the contractor do? Well, the contractor has to send another notice saying, PM, you haven't responded within your 2 weeks. We're giving you another 2 weeks to respond. And if the PM doesn't respond in the second lot of 2 weeks, then PM is deemed to have accepted the quotation that the contractor submitted. Now, that is really, really valuable. It means that if the client, the employer, doesn't make payment for that CE, contractor can proceed very, very quickly to adjudication based on this simple premise that project manager is deemed to have accepted the quote and that therefore that the money should be paid. So do operate that, but remember, it's not just, you know, these time limits that the PM has to comply with. The contractor's got to always send that second notice. The other thing to be aware of with regard to this default provision is that quite often when the contract's amended in the Z clauses, these provisions are removed entirely. So obviously, if they've been removed in the Z clauses, it's of no use to you. Next slide, please. Okay, so notifying. So we know this is this condition precedent, so really nasty clause that means that if you don't, as a contractor or subcontractor, notify the CEE within the time limit, you've still got to do the work, but you don't get paid, you don't get any extra time. Under a subcontract, it's a 7-week period, but as I've said before, often the Z clauses reduce that further. There is a little bit of a reprieve for contractors and subcontractors. This is this third bullet point where the project manager or the supervisor, so they're engaged by the client/employer, has to notify some of the compensation events. So these are described as those giving an instruction, issuing a certificate, changing an earlier decision, or correcting an assumption. That's clause 61.1. If you're not clear on which ones they are, then the final bullet point states GN guidance notes, states this applies to, and it's those CEs. So, and actually, sorry, it says 61.1, but it's actually 60.1. It's the listing the compensation event, the compensation events that PM or supervisor have to notify. So if the PM/supervisor doesn't has to notify them, then the contractor doesn't have to. So that 8-week, that horrible deadline doesn't apply to them. However, my advice to contractor and subcontractor clients is notify irrespective, get into the habit of notifying compensation events. I mean, for a start, if you just as a matter of policy notify compensation events, it sort of means you're saving time probably in some respects, because you're not constantly checking which ones contractor notifies, which ones PM or supervisor notifies. The other thing is as well, if you notify everything, it just means that if it subsequently becomes apparent that actually this CE isn't one that the PM should have notified, but actually is one that the contractor should have notified, then you're covered. So happy days, you know, you're not going to fall foul of, you know, missing that condition precedent. Next slide, please. So this kind of continues with the procedure. So what I want to look at here is the scenario. You know, we said initially with that initial slide that NEC tends to deal with the scenarios where everything's running fairly smoothly. But what do you do as a contractor in circumstances where, for example, you've notified a CE, project manager responds by saying, I don't agree. So from their perspective, that's the end of the story. You know, move on, complete the work, and they don't want to talk about it anymore. But obviously, contractor or subcontractor and a subcontractor may disagree with that. There may be a dispute. Is this a CE or isn't it? So what would the contractor or subcontractor do in that scenario? Well, my suggestion would be, I mean, you can do one of two things. The first is you approach the project manager to try and have a discussion, write to the project manager, try and get some discussion going about why they don't think it's a CE, and try to persuade the project manager that actually it is a CE. If that fails, and or at the same time, contractor might want to still provide a quote, partly because tactically that shows that contractor hasn't accepted the decision of the project manager. It's not necessary, it's not a requirement of NEC, but if you quantify it strategically as well, it just makes it a bit more real to the project manager. It shows that this matter hasn't just gone away. The other thing is that if, again, a quote submitted, project manager says they're going to make an assessment, the assessment's made and it's substantially less than the contractor's quote, contractor's not happy, what does the contractor do about it? Well, pretty much exactly the same. There's nothing specific in NEC about what to do, except of course in either of those scenarios, contractor can proceed to adjudication, but very often that's not practical on single CEs, and very often contractors busy actually physically doing the work, so hasn't actually got the time to devote to an adjudication. So what the contractor wants to be doing is keeping the discussions going with the project manager and keeping the process moving. So project manager makes an assessment, it's substantially less than the contractor's quote. Contractor doesn't think it's realistic at all. Again, contractor needs to be, you know, speaking to the PM, writing, explaining why it's not sufficient and seeing if a negotiated increase can be achieved, and or a negotiated agreement for that particular CE. And obviously, if agreement can't be reached on those processes, it looks like, as a contractor or subcontractor, you know, that the issue might be going to adjudication. Quite often what you find is that project managers are not agreeing on things as they go along. but their intention is to try and negotiate a resolution at the end, which isn't in the ethos of NEC. NEC is all about sorting, issues out now, so the employer stroke client has some certainty. But that's often not how it works, which is why, we started off with the slide about, this potentially being, one of the most problematic areas of NEC. So if we can move on to the next slide, please, Jen. So some of the provisions regarding clause 61, just to be aware of. So the first one is that the project manager can instruct a quote from contractor for a proposed instruction. So generally, when we're doing this whole CE process that, we already know could take a matter of weeks, the contractor proceeds with the work, irrespective of the fact that project manager might be saying it's not a CE, might be saying it doesn't agree with the quote. The contractor has still got to proceed with the work. It cannot just say, well, I'm not doing this work until we've agreed the sum, unless the instruction is for a quote for a proposed instruction. That's the exception. That work doesn't get done until the PM instructs it to be done. A proposed instruction isn't an instruction to do work. So this might be in circumstances where employer or client might be thinking of asking for some additional work, but they want to gauge what the cost will be before they actually instruct it. So as contractor, subcontractor, if you're in any doubt, is it a proposed instruction or is it an instruction? Just go back to the PM and ask for clarification. Third bullet point, early warning notice. It's an obligation on both parties to issue an early warning notice. All it relates to is a scenario where either party spots that something that's happened and it's going to do something that, will impact on the project. So things like increase the cost, increase the time taken to carry out the project, change key dates, all those sort of things. So it's not just limited to compensation events. So for example, if contractor was just generally being slow, struggling with labour, and the completion dates were going to move out because of that, strictly speaking, contractors should be issuing an EWN in regard to that, as much as issues that will possibly be compensation events. So I've already said that the obligation to issue an early warning notice is on both parties. As soon as one of them becomes aware of it, you've got to issue it. If contractor doesn't issue it when they should have, then what they get paid, if it transpires that it's a compensation event, is based on an assumption that they had given an early warning in circumstances where they hadn't. So any cost savings that the PM thinks could have been achieved as a result of issuing an early warning will be removed from the quote, so that the client, the employer, gets the benefit of those cost savings. So what if the project manager fails to give an early warning? Well, there's no specific penalty in the contract, but technically it could be a breach of contract, which of course is its own compensation event. So, if you're in a situation where you think the project manager could have, should have, but didn't issue an early warning notice at a certain time, possibly they issued it late or not at all, what you could do is issue a notice of a compensation event on the basis of project manager's breach of contract. Whether there'd be any cost attached to it is another matter. There might be, but again, strategically, what this might do is to show the project manager, that you as contractor, subcontractor, know and understand and properly operate the NEC form of contract. but also, you know, as individuals, we don't like being told that we've done something wrong. So what it might do is just make the PM pull their socks up and do things properly moving forward and operate the contract properly. Fourth bullet point, the project manager can request a quote based on an assumption. So this is clause 61.6. Why would they do that? Well, the quote has got to cover all items that that would be anticipated within the CE and include an element of risk. So without any assumptions, in some cases, the quote may end up a ridiculously huge figure. So if it was, you know, if the CE was something related to ground conditions, the PM might want to put in an assumption that the ground conditions are, you know, holy sand, or, you know, something that would make the work relatively, you know, less expensive and easier. Sand's probably not the right one. And so the quote is based on that. And then, you know, if the ground conditions, you know, in my ridiculous sand example, prove to be incorrect and it's all rock, then that's another compensation event and it's paid separately. Now, what you often find is a scenario where PM refuses to request a quote based on an assumption, and the contractor's position is, as I've said, that, you know, they're faced with issuing a really ridiculously large quote to take account of all the scenarios. So the issue then arises as to whether the contractor can quote based on assumptions. So the answer to that technically is under the NEC, no, that's not allowed. But if those assumptions are included in the quote and it's made clear that the price will increase if those assumptions manifest themselves, then, you know, that's a practical way of dealing with things. Assuming, I mean, probably the first way of dealing with it is to approach the PM and say, look, you know, these are, if we, you know, can we make the quote on these assumptions? And if the PM says, yes, you can, then that's fine. If the PM refuses, contractor might, you know, the only practical way of providing a quote might be to put in some assumptions, but there is a risk to doing that. The risk is that the project manager accepts and then, you know, the assumptions come to light, contractor claims extra, and the PM argues a very strict contract point that I've already mentioned, that NEC doesn't allow contractor to include assumptions. There's no case law on this, but what the response would be that if PM has accepted the quote under just general contract law, an acceptance of a quote has to be accepting all of it, otherwise it's not acceptance. So if the PM accepted all of it, but then said, but I'm not accepting the bit about the assumptions, then that's not an acceptance. If the PM accepts the whole thing, then it is effectively accepting those assumptions under contract law. So that would be the argument. But what I want you to understand is that, you know, there's no case law on it. So, you know, the argument comes with some risk, particularly if that assumption is high value. And finally, compensation events aren't notified after the defects date. So that's after effectively the end of the defects liability period. So next slide, please, Jen. Just bear in mind what your quote has to cover for a compensation event. So it's got to cover the financial implication of any extra work. It's also got to cover your extension of time, so any extra time to be added, so any delay that's been caused by the CE, and also what I've called L&D, the loss and expense, which is the contractor's extra time on site because of the delay that's been caused. So by analogy, in JCT, we have a variation clause for extra work, we have an EOT clause for an extension of time, and we have loss and expense clause for the money relating to that time. So the extension of time is needed so that contractor doesn't have to pay liquidated damages, stroke delay damages, stroke general damages, and also so that it's entitled to get paid its loss and expense, its own cost for being on site for that delay period. So don't forget that when you submitting your quotes, don't forget about the time and the loss and expense. Also, no, you're fine, Jen. The project manager can request alternate quotes, which is fine, provide them. But then remember, if you're doing your default notice, so you've provided your alternate quotes, PM hasn't responded in their 2-week timescale, so you're sending your 2-week notice, giving them another 2 weeks to respond. At that point, you have to make it clear that if they don't respond within that extra 2 weeks, which quote you are going to say is deemed to be accepted. If you think about it logically, unless that happens, you're in a position where you're deemed to have the PM's deemed to have accepted a quote, but 2 have been provided. So the difficulty is, well, which one is deemed to have been provided? So just bear that in mind. So we've already dealt with the default position. So the guidance notes. So I've put this in. It relates to clause 62.6. I like the guidance notes in the NEC. Quite often they have some helpful snippets. So I've put this quote in, and it's just saying it's important that the PM does not delay the assessment of CEs by, for example, waiting until, sorry, this should be changed, not charged, until the changed work is complete before deciding whether or not to accept the contractor's quotation. So, you know, use that quote in discussions with PMs, because again, strategically, you know, nobody likes to be told that, you know, they're misbehaving, they're not following the contract properly. And that, you know, in my experience, you know, this practice is, you know, in my experience, what a lot of PMs do. They sort of hedge their bets. They, you know, they often reject a quote or say they'll assess it and then they don't. And, you know, typically, you know, they're looking to see actually how much it actually costs so that they can get it for a lower price very often. Which brings us on to the next point, what happens when the different parties have accepted quotes? So what if the PM accepts a quote? Well, they're accepting it on behalf of the client or the employer, but the employer can still go to adjudication to get that reversed. It's quite difficult and there's quite a lot of case law on it, and the courts aren't keen to change the PM's decisions for lots of practical reasons. You know, what they'll say is, you know, the PM, you know, was on site at the time, you know, knew about the project. So, you know, there's a really high bar for client stroke employer to get over, you know, what would be, you know, months later in trying to establish that the PM was wrong. If the PM accepts the contractor's quote, it's going to be really difficult. There's no case law on this, but I think it's pretty much impossible for the contractor to go back and say, well, actually, my quote was wrong. I need more money. So, you know, that's why, you know, I say you need to be really careful and make sure your extensions of time are included within your quote. Don't forget about it. So moving on to clause, so this is clause 63, assessing compensation events. So how do we assess them? So the financial side of things are assessed as the effect of the compensation event upon the actual, so ignore the defined cost for the time being. So it's the actual cost of the work already done in regard to that CE, and the forecast cost of future work. Now that makes sense because work already done, we know the actual cost of that, we know what it cost. the future work not already done, you know, we don't know what that is going to be. It's always going to be a forecast. So therefore, those two elements. And then when we have those costs, you put on the resulting fee. So the fee is a percentage, which is basically overhead and profit. Now, don't subcontractors, contractors, the fee percentage goes in the contract data part 2. We did a real live seminar today in the Northeast, and people were talking about parties putting 0% in for the fee percentage because they didn't understand what it was about. So that's, if you put 0%, you're actually saying, I don't want any payment to cover for any profit or to cover my overheads. So, you know, not a great business decision, I don't think. In terms of, you know, what's the actual cost, excuse me, and the forecast cost. So the defined element, the defined cost is just the costing under the schedule of cost components, which is next month's exciting topic. So how do we decide what's the actual cost of work done and the forecast cost of the work not yet done? Back to basics, it depends upon whose duty, whose responsibility it is to notify the CE. So if it's the contractor's obligation to notify the CE, the actual cost is calculated up until the CE is notified, which is logical because you know when you notify a CE what the cost is that you've incurred in respect of that CE work at that time, and the forecast cost of the work not done is forecasted from that date onwards. That does not change. So if, for example, you submit a quote on that basis and the project manager says, no, I don't like that quote, please submit another one, it's still on the basis of the first quote of the actual and forecast cost. That date doesn't move just because a new quote is being asked for. If, on the other hand, the quote concerns a CE that is notified under the contract by the PM or the supervisor, then the date of that you switch over is the date when the PM or supervisor issues the instruction or the certificate or whatever it is that leads to the CE. So that will be a much earlier date. So up until they issue that, up until that, it's actual costs. So I would have thought, except in exceptional circumstances, that would generally be a relatively small amount of work, assuming the PM supervisor are on the ball and are issuing their notices, certificates, etc. promptly. And then after the date of whatever they issue, instruction, certificate, etc., is done on forecast cost. And again, that does not change if things evolve as the project goes on. Next slide, please, Jan. Covered all of that. Yeah, so that's everything that I've just explained about the switch date. So if we can have, thank you. So just other issues about assessing a compensation event. The first one, I've already referred to this. Compensation events are the only way in which a contractor can get additional money or extra time in relation to compensation issues. The only other real way is through an acceleration clause. And of course, acceleration, it's a different clause, but it's a wholly different issue to a compensation event. Be careful because, of course, the compensation events are at clause 60, but there are others dotted around, particularly there are some in the X clauses, so they're optional clauses. We've dealt with the implications of not issuing an early warning notice on the valuation of a CE. Third bullet point, in your quote, you can include risk allowances. So it's not technically the way to regard it, but I always regard a quote as being, it's like a mini lump sum contract. So it includes your time, cost of your time, but it also includes risk allowances for doing the work, taking account of the fact that you're forecasting a lot of your cost. And you're only allowed to include risk allowances which have a significant risk of occurring, and you can claim them. So even if the contractor's risk under the contract, so ground conditions, might be contractor's risk under the contract, but with a CE it's different because that's all extra. So include those risks. Fourth bullet point. The CE is assessed on the assumption that the party doing the work, subcontractor, reacts competently and promptly, and that costs are reasonably incurred. So that's to avoid a situation such as, contractor just being really slow and claiming the cost under a CE, or contractor putting a load of staff on site to claim lots of money on a CE. So it's to kind of regulate what the contractor's entitled to claim, and ditto with materials, can't go necessarily to the most expensive supplier. So if we can move on to the next slide, please. Thanks. So in terms of assessing delay, so all done under this CE, so all done in a quote. So it's basically the length of time, the delay that is caused by the CE to the programme. We're talking here about the accepted programme. So that becomes really problematic if, for example, project manager, for whatever reason, isn't agreeing the programme, so isn't accepting them, and particularly if there are no accepted programmes from the project. The same point applies with regard to key dates as well. Next slide, please. So when can a project manager make an assessment? So it's the project manager receives the quote, decides that it's not acceptable, and decides to make its own assessment. Well, 4 scenarios. First of all, if the contractor fails to submit a quote within the timescales. Secondly, project manager doesn't agree the contractor's quote that's been submitted. Third, the contractor's quote doesn't include a programme dealing with time, so it claims the time but doesn't include the programme. And finally, the contractor submits a quote, but the project manager hasn't accepted the contractor's latest programmes for one of the reasons stated in the contract. So that's one of the reasons why, the programming is really important. It's really critical that contractor gets the programmes correct to avoid them, to avoid a situation where PM refuses to accept them. Next slide, please. Yeah, so we've covered all of that, so we'll just move on to the next slide. So implementing CEs, so this is nothing to do with physically doing the work. As I've said already, contractors just got to keep doing the work. This isn't a situation where the contractor can sit back and say, well, I'll start this bit of the work when we've got the price for the CE agreed. It's not what this is all about. This is about the kind of price, I suppose the impact of the CE, so price, time, etc., being agreed and accepted between the parties and implemented into the contract. So in my mind, I always think of the option A contract where you have the activity schedule, and once the implementation of the CE is effectively where the extra money gets effectively put into the activity schedule, which then means that once the work's completed, the contractor can claim it in its interim application. So that's what implementation about. It's not about actually physically doing the work, which should be ongoing. So second bullet point, the implementation occurs when project manager accepts the contractor's quote in full. Project manager makes its own assessment. And obviously that's implemented, but contractor, of course, is still entitled to proceed to adjudication or dispute the project manager's assessment to get the assessment increased or a greater extension of time if the contractor feels that it's entitled to that. And then the third scenario where we have implementation is where the contractor's quote is deemed accepted under those default provisions that we've looked at. So we've covered the rest, so if we can just move on to the next slide, please. Thanks. So just a quick checklist. Remember the early warning notice, obligation for both parties. If the PM doesn't submit it, it's a breach of contract, potentially a CE for breach. If the contractor doesn't submit the EWN, there's a cost penalty on payment of the CEs. Remember the CE notification. Think about doing what I'm suggesting in that you just notify all CEs and remember that time limit, 8 weeks, 7 weeks for a subcontract, potentially both will be reduced in the Z clauses. Has the quote been submitted? Don't forget to submit it. Include not only the cost, but also extension of time and also the cost of the time. Just remember that switch date and remember once it's been implemented to claim it in your interim applications. What contractors sometimes do is claim the sums that they've put in their quotes, even if it's not been implemented. But you just need to be careful in your adjudications and make sure that you make a claim for a particular issue, that it is a CE and that the sum is due and that it should be paid in that case. So next slide, please. So I think this is just another summary. Yeah, I think we've covered all of that. So if we move on to the next slide, please. So this is what I think is the most important case law that we have for NEC, and it covers how you quantify a CE. So before we go into the detail, just a few caveats. So first of all, it's a Northern Ireland case. So in the courts in England and Wales, which is our jurisdiction, and also Scotland, which is a slightly different jurisdiction, but the same point applies. This case is persuasive, but it's not binding, so the courts aren't bound to follow it. So whether or not it will be, remains to be seen. The second point to bear in mind, it was an NEC professional services contract, which might make a difference. The third point to note is that in this, that the facts of the case were that neither party complied with all those fairly convoluted provisions that we've just spent the last hour discussing. So, for example, the scenario was that the project manager changed the work that the consultant, the professionals were carrying out, but failed to notify a compensation event, and it was a CE number 1 change to the scope, and so it was on the PM. It's the PM's responsibility to notify. So it failed to notify and it failed to request a quote. So double breach of contract. The consultant nevertheless did the work, which was as it should be. And once it had completed the work, it provided a quote. And slightly bizarrely, it provided a quote on the basis of NEC. So it forecast its cost, even though it had by that point completed all of the work, so it knew what its cost was. So effectively, it was complying with the NEC form of contract, because, of course, we know that from what we've seen about the switch date, you calculate your actual cost up to the point when the PM instructs the additional work, and you do your forecast cost from then onwards. And the guidance notes are clear that doesn't change if the circumstances change. So under the contract, technically that was correct. But of course, it's a slightly false way of doing things when the work's being completed. So bear all those points in mind. And if we can just move to the next slide, please, Jen. What the Northern Ireland courts basically said was that by the time these matters get to court, bearing in mind under NEC, you've got to adjudicate it first and then you go to court. Typically, you're not going to adjudicate until you've got to the end of the project. Not always, but that's how it works in practice. So, you know, typically you're going to be getting to court a year after that. So, you know, even a very prompt adjudication, you know, will mean that you're not going to be getting, you know, to trial at court probably, you know, until well after the defects period has expired. And what the court said was that therefore, when it was being asked to quantify a CE, what it wanted was the actual cost, what it had cost. So how we do things in JCT, you know, we've got timesheets to show who worked on this CE, how long they worked on it, what day they worked on it, what their charges are. We've got invoices for the supply of plant and machinery, how long it was on site working on this compensation event. We've got invoices for materials. So that was what the court said it wanted to see, which really flies in the face of NEC, because NEC is not about that at all. It's about providing a quote, which will substantially be for a forecast cost. So I think the problem with this case is that you have one way of doing things under the contract, and then it's completely changed when you get to court. The impact for contractors and subcontractors is that, as well as preparing quotes, you still have to, behind the scenes, be preparing that critical documentation that, you know, is quite time consuming and quite difficult to do on a practical level, to show, you know, how many people were working on that CE, you know, when they were working on it, how many hours, what they were doing, what, all that detailed information, which I think, you know, was never intended, you know, within the NEC form of contract. So this is why I'm sort of debating, will our courts, will the English courts follow this case? I don't know. I suspect the English courts will be more inclined to go along and follow the NEC contract, because we've had quite a lot of case law now. You know, the courts, the judges, you know, are quite up to speed on NEC, but who knows? Because the way they would have to do it would be to look at a quote and say, well, that quote was provided, you know, when the instruction was given, sorry, 3 weeks after the instruction to provide a quote was given. And they would have to look at it from the perspective of, at that time, how reasonable was it? Was the contractor reasonable in including that risk? Yes or no, or should it have been slightly less? Ditto the, you know, the estimated costs for carrying out the work. So they'd have to go through it and put themselves in the shoes of the contractor to see what was reasonable. Now the judge won't be able to do that, so, you know, what they would have would be probably an expert quantity surveyor advising them, you know, on, you know, all those issues. So, you know, this is a, you know, we need to wait and see what the courts will do. What I can say is that in my experience, the adjudicators will want to see the timesheets, the paperwork, because they follow this case. You know, they want to see the supporting documentation. And of course, as contractor, you are putting yourself, or subcontractor, you're putting yourself at real risk if you don't have the supporting information, you know, that backup to show exactly how much time, cost, etc. The issue has cost you. So bear that in mind. I do think it's unfortunate for contractors and subcontractors because, as I say, it means that you have to not only provide a quote, but you also have to provide that documentation, or at least have it prepared in case you need to support your claim. Now, I think maybe my last point is you might be kind of thinking, well, we would never adjudicate, so you know we don't need to have that documentation. But you need to think about what leverage you would have if you haven't got that documentation in trying to persuade a PM to increase the value of a quote. And I think you probably have very, very little leverage. Whereas if you can go along to a negotiation with the PM and say, well, you've assessed this at, you know, £200, you know, my quote was 26,000, but here are the actual costs, and it actually came in at you know, 25,000 or 20,000. You know, you're showing that you've got that leverage and that ability to proceed to adjudication. Without that documentation, the PM knows that you don't, therefore will have very little incentive to increase whatever they've assessed and whatever's been paid. So just bear that in mind, please. Now, I think that's everything. We can move to the next slide, Jen. Yep. So as always, happy to deal with any questions, or if you want to drop me an email, I'm happy to answer those, or save them for next month, because I think Jen's got to get off for another meeting. You're on mute. You're on mute, Jen.
Here we go, chatting. So sorry about that. So now I was just saying there's no questions that's coming for you whilst the webinar has taken place. But if anybody does have any questions, then please feel free to pop them in the chat and we can ask them to Sarah now, or likewise, as she kindly offered, you can send her an email. The next NEC webinar that's taking place on Tuesday, the 21st of February, and that again is at 1 o'clock. So looking forward to that. As I mentioned earlier, I'll send the slides out to everyone who's attended. And if anyone wants a certificate, then please feel free to message me, and there'll also be a copy of the recording uploaded to our YouTube channel, so you'll be able to watch it back on there should you wish. I'll pop my email address into the chat now, so if anybody does want to contact me, then you can do that. But I would say, from the resounding silence on the chat, Sarah, that nobody has any questions because you've explained everything so beautifully. So we'll say goodbye if that works for people, and thank you so much, Sarah.
Thanks very much, everyone.
All right, bye-bye.